Hello, everyone. This is Leite Marques from Kincaid in Brazil, and the topic I would like to bring you today is that bills of lading clauses are valid and accepted by Brazilian courts. At first, such a statement should not seem so relevant, taking into consideration that when two parties establish a contractual relationship, the contractual provisions agreed therein should apply. But considering Brazil as a cargo-friendly jurisdiction with a past history of sometimes disregarding bill of lading provisions in claims brought by cargo interests against ocean carriers, it is in fact interesting to highlight that in recent years, the understanding from the courts have been changing for the better and changing for what is right, if I may say. Be it a limitation of liability clause, an arbitration clause, or even a foreign jurisdiction clause, which is the one I would like to highlight here, those should all be applicable in Brazil. In relation specifically to the foreign jurisdiction clause, it should be effective to, if not prevent a judicial proceeding in Brazil, at least lead to a dismissal of a certain lawsuit if one is brought before a Brazilian court. The 2015 Code of Civil Procedure brought a new provision, Section 25, establishing that no Brazilian judicial authority is responsible for processing and judging a lawsuit when there is a choice of exclusive foreign jurisdiction clause in the case of international contracts if raised by the defendant in its defense. Since then, Brazilian courts have slowly been changing an old understanding that used to accept Brazilian jurisdiction and disregard the foreign jurisdiction clause established in the Bill of Lading. Nowadays, it is a standard understanding from the Brazilian courts in all levels to recognize the validity of the foreign jurisdiction clause in a BL and dismiss a claim in Brazil. This position acknowledges the autonomy of the contracting parties, and a reputable judge in Brazil who is an expert in maritime matters normally emphasizes that the Brazilian government should not babysit the parties that did not negotiate well their contracts or did not give proper importance to the contractual clauses, meaning that such parties cannot later challenge the validity of those clauses at court and seek the protection of the Brazilian judicial system to change what has been agreed. Such understanding also applies to a subrogated cargo insurer, as, in the words of the court, subrogation in the rights of the insured also means adhering to the terms of the contract, which should have been observed by the insurer when contracting, given that the exercise of that said right is conditioned to the terms agreed on by the insured. Needless to say, such position represents a development to help bringing more legal certainty to cargo carriages and contractual relations that have any ties with Brazil. Thank you to all the listeners of Snippet 3 podcast.